Hello again, and thank you for joining us this week for Coffee with Capital. Today's topic is what happens if a seller dies while under a TREC contract for the sale of a property. For many of us, our first thought is that the contract must be terminated if the seller isn't around to perform his or her obligations, right? If this is what you think, then think again. Stay tuned to hear the shocking answer. The legal rule is that the contract is still valid, and the estate of the decedent must perform. Yes, failure of the estate to perform could result in a breach of contract. The buyer and the sellers have a right to open up an administration and have a personal representation appointed in order to fulfill the obligations under the contract. Does this differ if there are multiple sellers and only one dies? We recently had a scenario where there were 5 sellers or heirs that entered into a contract to sell their deceased mother's property. After execution, one of the sellers passed away, and the kids of that seller didn't want to sign. They thought that when one seller passed away, the contract was just null and void. Just know that this is not how the law reads on this matter. The buyer might have an out under the contract if they want one, because the death of the seller may delay matters, especially if personal representation has to be appointed. Going through the court system can add additional time, and if the buyer does not want to agree to extend the closing date, then the seller will be in default, allowing the buyer to walk and keep his earnest money. I hope this has been helpful. Please join us again next week for another cup of coffee with Capital. And you are always welcome to reach me with questions at any time. I'm Kelly Yount with Capital Title, and I look forward to serving up another cup of coffee next week. See you then, if not sooner. Have a wonderful week.